We are following that breaking news out of Colorado, where the state Supreme Court has ruled that Donald Trump cannot appear on the state's primary ballot because of his attempt to overturn the 2020 election. That ruling reverses a lower court's order that concluded Trump had engaged in insurrection but could not be disqualified from holding office. Now, in response to that lower court ruling, Sherrilyn Ifill, the former president and director counsel of the NAACP Legal Defense Fund, wrote this opinion piece for the Washington Post. I use the word radical deliberately. The 14th Amendment was conceived of and pushed by the radical Republicans in Congress after the Civil War. They were so named because of their commitment to eradicating slavery and its vestiges from American political life. It was of this understanding that Section 3 was born. Most lawyers never learn about Section 3 during law school or thereafter. The recent scholarly duels that have emerged over its meaning reflect its surprise introduction to many seasoned constitutional scholars. But there is little room for confusion in interpreting it. Joining me now is Sherrilyn Ifill, civil rights lawyer, founder of the 14th Amendment Center for Law and Democracy at Howard University, and former president and director counsel of the NAACP Legal Defense Fund. Sherrilyn, thank you so much for being here. I mean, once you have the 14th Amendment Center at Howard in your title, we know this is bigger than just this case, quite obviously. And I very much want to talk about the sort of racial underpinnings of this law and the way in which I think people have forgotten January 6 was a concerted public effort to disenfranchise the votes of a coalition, a multiracial coalition of voters powered in large part by black votes. And it's almost as if people have forgotten that history when they sort of question how and why and whether the 14th Amendment is applicable in this case. But it seems to me quite obvious that there's a racial element here that echoes very directly back to the sort of intention when it was written.
Yes, the Reconstruction Congress, Alex, understood that the spirit of insurrection in the South was very much obviously tied to the issue of slavery and to the question of Black people and their citizenship. And likewise, January 6th pulled those two threads. And Trump pulled those threads by inciting an insurrection and by inciting an insurrection on the theory that he had been cheated by voters in Atlanta and Philadelphia and Detroit and Milwaukee, and by Ruby Freeman and Shay Moss, who he called hustlers. The racial underpinnings of Trump's theory were very much on display for anyone who wanted to see it. And I would say even, in the final days of the Civil War, it would have been shocking and appalling to see a Confederate flag paraded through the United States Congress as we saw on January 6th. So that Reconstruction Congress was very serious, very clear. They had looked in the face of insurrection and had determined that we needed something to protect the new democracy that these Civil War amendments were designed to create. And so many of us learn about the 14th Amendment. We know about equal protection and birthright citizenship and due process, but we don't learn about the sections of the 14th Amendment that were created by those framers to allow us to have the tools we need to protect our democracy against precisely the kind of action that Donald Trump engaged in.
Yeah, one would think in a way that if it was Obama who Donald Trump was trying to unseat rather than Joe Biden, it would be more obvious for people, sitting on the Supreme Court to understand the direct sort of racial element or racial post-racial society goal, which is to say racist goal that lay at the heart of the January 6th insurrection. But I want to ask, given how the Supreme Court has treated the issue of race in the last year, effectively saying we live in a post-racial society, we shouldn't take it into account in hiring decisions or college admissions, how optimistic are you that they are going to understand this in the strictly constitutional way in which it was written?
Yeah. Well, I'm very gratified by the Colorado Supreme Court's decision. It is, as Representative Raskin was saying, a very careful and meticulous decision. It is airtight. This is really a test for our Supreme Court. In years past, the Supreme Court has recognized the need, particularly in cases involving the president, in some instances, to rise above partisanship. But I want to be clear about two things, Alex. This case is not about partisanship. These are the words of our Constitution. That's number one. Number two, this case does not require you to believe that Trump is racist or that the insurrection was racist. That's not part of this case. Participation in an insurrection makes you ineligible if you formally took an oath of office to return to office at either the federal or the state level. That's what Section 3 of the 14th Amendment says. It is like having to be 35 to be president. If Trump were 34, he could not be on the ballot. He participated in an insurrection, he cannot be on the ballot. And of course, the irony is that it was Trump who, for many years, falsely accused President Obama of not being eligible to be president because he lacked, as Mr. Trump charged at that time, birthright citizenship. So this is about eligibility, the qualifications to be president, to have been born in this country, to be 35 years old. And after the Civil War, those framers added another eligibility requirement, which is that you have to be loyal to the Constitution of the United States. So this doesn't require the court to engage in any racial analysis. It requires them to uphold the words of the 14th Amendment. And I want to really congratulate the lawyers at Crew, Noah Bookbinder and Donald Sherman and the entire crew for being courageous enough and clear enough to pursue this case and for putting on such an airtight case before the court. This is a test of our United States Supreme Court, not of Donald Trump at this point, not of the lawyers in the case, not of Colorado. And we will have to see what happens.
We sure will. Sherrilyn Ifill, thank you so much for your time tonight. I appreciate it.
Thank you, Alex.